April 1995, the Oklahoma City bombing. I mean, that's a moment that
Yeah,
it permanently altered the American landscape.
completely.
At the time, it was the deadliest act of domestic terrorism in U.S. history. 168 lives lost.
And those 19 children in the building's daycare.
19 children. It's
Right.
just an unthinkable trauma. And today, we're taking a deep dive not just into the horror of that attack, but into its meticulously managed conclusion, the execution of Timothy McVeigh on June 11th, 2001.
That event was really singular in American legal history. So for this deep dive, we've collected sources from, Department of Justice documents, legal analyses, all the way to sociological research based on interviews with survivors.
And what's the mission here? What are we trying to figure out?
Well, our mission is to analyze McVeigh's death as a kind of dual event. We're looking at how the state pursued this rigorously observed procedural justice, while at the same time satisfying a really powerful public demand for vengeance and what everyone kept calling closure.
Right. How the system navigated that impossible line and what the lasting policy consequences were. Okay, so let's start at the beginning. Who was Timothy McVeigh?
Well, McVeigh was a decorated Gulf War veteran, but he became profoundly disillusioned and radicalized by this deep-seated hatred of the federal government.
And he saw himself as a soldier, not a criminal.
Absolutely. He considered it a justifiable act of war against what he saw as a tyrannical system.
And his choice of date, April 19th? That wasn't random, was it?
Not at all. It was deeply symbolic. He was targeting two events that had become rallying cries for the anti-government far right.
Waco and Ruby Ridge.
Exactly. First, the 1992 Ruby Ridge incident. But the date, April 19th, was the 2-year anniversary of the end of the Waco siege in 1993, which, ended with the deaths of 76 people.
So in his mind, the ATF and FBI were the aggressors.
He was obsessed with that idea.
Yeah.
That they were using deadly force against their own citizens, and he had to strike back.
And this is where it gets strange, because the blueprint for the attack, he didn't just come up with it himself. He was inspired by a work of fiction.
That's right. His operational guide was heavily influenced by the Turner Diaries, a notorious, white supremacist, anti-government novel.
And it basically lays out the whole plan.
It provides the ideology, but also the specific tactical idea of blowing up a government building to spark a wider rebellion.
Wow. It's fascinating, too, that his initial thought wasn't a building. He was considering individual assassinations.
Yeah, he was. He thought about targeting Attorney General Janet Reno or Lon Horiuchi, the sniper from Ruby Ridge.
But he decided against it.
He shifted from individual targets to what he called a command center, the federal building. He believed that would make the loudest, most disruptive statement possible.
And he saw everyone inside, federal employees, citizens, even the children, as collateral damage in his war.
He did. The successful legal prosecution, though, it hinged on very specific federal offenses.
Right, because of the scale of it.
Exactly. The sheer magnitude of the loss could have complicated things, but he was found guilty in 1997 on 11 federal offenses, and crucially, this included the murder of 8 federal employees.
Which allowed it to proceed under federal death penalty statutes.
And that streamlined the entire path to his execution.
Okay, so the act itself was horrific, but what really defines the aftermath is how the American legal system responded.
Yeah.
Let's move to the trial itself, which had to be scrupulously fair, even for him.
The effort they made to uphold due process here it's really fascinating, especially with the immense public pressure for, a quick execution.
And the biggest step was moving the trial, right?
That was the most important procedural safeguard. They moved the entire trial from Oklahoma City all the way to Denver, Colorado.
Just to find an impartial jury.
You had to. It was the only way to find people who were far enough removed from the site of the trauma.
But at the same time, they made these huge, unprecedented accommodations for the victims. I mean, they set up an off-site courtroom back in Oklahoma City.
They did. So hundreds of family members and survivors could watch the Denver trial on closed-circuit television. It was this very visible attempt to balance fairness for McVeigh with the emotional needs of the victim.
It's a real tightrope walk.
It was. But the trauma McVeigh inflicted, it didn't just affect individuals. It had these long-term structural consequences for American law.
You're talking about AEDPA.
Yes, the Anti-Terrorism and Effective Death Penalty Act of 1996. The political momentum from the bombing is what got that passed.
So hold on. The justice system, which is supposed to be objective and impartial, actually bent to political pressure and fundamentally weakened protections for all future defendants.
They justified it based on expediency and finality. AEDPA, it drastically cut the scope of federal habeas corpus review, especially in capital cases.
Okay, for our listeners who might not be steeped in legal terms, what exactly is habeas corpus?
Of course. So think of habeas corpus as the ultimate safety valve in our legal system. It's the way a prisoner, after they've exhausted all their state appeals, can ask a federal court to see if their conviction violated their constitutional rights.
And AEPA cut that back.
Sharply. It imposed new, tight deadlines, like a one-year limit to file a federal appeal. It essentially wrote the public's desire for a quick, final ending into the law.
Even if it meant less rigorous review for people on death row.
That was the trade-off.
And that gets us right to the core philosophical tension here, this line between retribution and revenge.
And that's a line the law tries very hard to maintain. Historically, the law accepts retribution, the idea of proportional punishment by the state to restore a moral order.
It rejects revenge.
Right. Revenge is seen as purely emotional, personal satisfaction. The legal system isn't supposed to be driven by feelings.
But in a case like this, with 168 victims, that collective need for emotional satisfaction has to go somewhere.
Exactly. And that's where the line just blurs. After the Supreme Court cases in the 70s that dealt with the death penalty, like Gregg, the idea of deserving punishment was allowed back in.
So the state was essentially allowed to deliver a kind of collective sanctioned vengeance.
It functions that way. The execution had to feel like it settled a debt, not just to the law, but to the nation's collective psyche.
So if the execution was both a legal procedure and this huge psychological event, let's talk about the logistics. June 11, 2001, this was the first federal execution since 1963.
The arrangements were unprecedented. Attorney General John Ashcroft decided 10 People Media, official witnesses, would view it live in Terre Haute, Indiana. But the spectacle was really broadened for the victims.
And that's where the Oklahoma City viewing facility comes in. It really highlights that dual purpose, doesn't it? Justice and spectacle.
It does. An additional 222 victims and survivors were allowed to watch via closed-circuit telecast in Oklahoma City. So you have a total of 232 witnesses, an extraordinary number.
All designed to maximize this feeling of a state-sanctioned reckoning.
And they had to control that spectacle. The rules at the remote viewing facility in OKC were incredibly strict.
To keep it from becoming some kind of, shock media event.
Exactly. Absolutely no video cameras, no recording devices, no cell phones, nothing. The state needed to provide the site of death to the victims, but maintain total control over that image.
And the research among survivors shows just how deeply they needed this. He wasn't just a criminal to them. He became a fixture in their lives.
That's right. The term sociologists use is a negative parasocial relation, which is, a very academic way of saying that McVeigh, through his defiance and his media presence, became this constant communicating enemy in their lives.
He was involuntarily occupying their mental space.
Yes. And for many, the execution was necessary to finally terminate this involuntary relationship, to get him out of their heads.
Wow. That's powerful. So let's look at McVeigh's final moments. How did he conduct himself?
McVeigh controlled his final moments through nonverbal communication. Witnesses universally described him as expressionless, cold, like a statue.
He was still playing the role of the soldier.
To the very end, showing absolutely no remorse.
But then the curtain opened, and there was this final, powerful exchange.
There was. McVeigh physically lifted his head from the gurney, and he slowly, deliberately stared directly into the witness rooms.
What did the witnesses make of that?
Few saw it as neutral. It was called a glare, a look of defiance. One witness was quoted as saying, "It was almost like the devil was inside him looking at us."
Though some people saw something else, didn't they? A bit of a crack in the facade.
A few noted that his jaw quivered, which suggested maybe a struggle for control in those last seconds, but his biggest statement was what he didn't do.
He was silent.
Yes. He declined to give a final verbal statement. He robbed the state of that ritual. Instead, he released a written one, the poem Invictus.
Which means unconquerable.
The ultimate act of defiance. It's a poem about mastering your own fate, about being unbowed.
And for the people watching, that silence must have been incredibly frustrating.
It was. Some were relieved, that he didn't use the moment to cause more pain, but others were just left frustrated. It was his final refusal to apologize, to explain, to give them anything that might help them heal.
After it was all over, President Bush said the victims were given not vengeance, but justice. But the sources we've looked at tell us that the promise of closure was really a myth.
The sociological analysis is very clear on this. Closure was an unrealistic expectation. It was pushed by the state and the media, and it confuses legal finality, the death of the perpetrator, with personal psychological healing, which is not linear.
And we have that one quote from a family member.
A very striking quote. He said, "The only closure I'm ever going to have is when they close the lid on my coffin."
Which just perfectly illustrates that gap between a legal resolution and any kind of personal peace.
It does. The execution settled the state's account, but it didn't guarantee an emotional settlement for the individuals.
Speaking of victims' voices, we have to touch on the role of victim impact statements, or VIS. They became hugely influential right around this time.
They did. And the intention behind them is noble, to give a voice to those who were most harmed. But the research shows that their introduction really shifted how justice is sometimes delivered.
How so?
The statements can influence sentencing by triggering specific emotions in judges or juries, particularly anger.
So the decision starts to shift away from just the defendant's culpability and more toward the severity of the victim's emotional pain.
Precisely. And this makes the entire process vulnerable to what experts call outcome bias. When decision makers are exposed to really powerful emotional testimony, they tend to overweight that harm and then look for evidence to support a harsher punishment.
So the sentence can depend heavily on how a victim presents their trauma.
It can, which raises serious questions about consistency. We see this so vividly in the case of Suzanne Bosler.
She was the victim of an attempted murder, and her father was murdered.
That's right. In early hearings, her highly emotional testimony describing her pain, it contributed to the jury sentencing the offender, Campbell, to death.
But the case had multiple appeals.
It did. And at a later sentencing hearing, she returned to the stand. But this time, she was calm, unemotional, and she explicitly rejected the death penalty. She argued for life imprisonment.
And the jury gave him life.
They did. Her case is just this perfect illustration of the variable and sometimes inconsistent power of a victim's emotional input on the final judicial outcome.
It really just underscores the central finding of this entire deep dive. McVeigh's execution forced the justice system to operate right on that fragile border between legal procedure and collective emotional demand.
And we have to conclude by reiterating the permanent structural legacy of that balancing act. The Anti-Terrorism and Effective Death Penalty Act of 1996. That law, fueled by the public desire for a swift end after the bombing, is still the law today.
So here's a final thought for you to carry with you from this. When a national trauma creates such an overwhelming public demand for swift justice, we really have to ask, what are the unseen long-term costs to legal integrity when a society prioritizes expediency and finality over the rigorous, slow procedural review that's meant to protect the rights of all citizens?
The speed of McVeigh's execution may have terminated one involuntary relationship for the victims, but it ushered in legal changes that systematically reduced procedural protections for everyone else. What does that policy trade-off tell us about the foundational nature of our justice system?